Hello, this is John Friedland with AGWS Business Development, and today for our webinar series, our AGWS University 2020 webinar series, it will be presented today by David Robertson, the Executive Director and President of AFIP, as well as Bob Harkins, our Vice President of Training at AGWS. Thank you very much for joining, and here we go.
Thank you very much, John. Good afternoon again, everyone, and welcome to F&I Insights. F&I Insights is our monthly webinar series that, as many of you know, is presented the second Wednesday of every month at 1 p.m. Central Time. Our discussion today is really 4 bullet points. Number one, we'll get into a bit later. Dave Robertson will reference Hudson Cook's spot delivery publication as we look at CFPB, FTC, and Attorneys General regulatory hot topics. I think you'll enjoy that because the CFPB finally gave us a definition of abusive. They've defined unfair and deceptive, but now we have a definition of abusive. Dave will handle that. And also from an FTC standpoint, they've adjusted the maximum civil penalties, upward of course, for the FTC Act as it relates to UDAP violations. So we'll get into that a little bit later. Number two, we're really excited about this, and this is our partnership, our relationship with the Association of Finance and Insurance Professionals. That's the American Guardian group of companies, specifically our university, our partnership with AFIP relating to the compliance checklist and dealer aid solutions for non-public personal information, NPI as it's called certainly, as it relates to the safeguards, red flags, and disposal rules. Number three, a bit later, we'll get into best practices for rate administration and product pricing. Dave and I will chat with you a little bit about the NADA Fair Credit Compliance policy and program from a rate administration standpoint. And then most recently, just the middle of last year, the NADA Model Leadership Policy for voluntary protection products as it relates to product pricing. Number four, and most important, is where we're going to begin. And that is AFIP's Dave Robertson will kick off our webinar today with the latest Military Lending Act developments. So with that in mind, let's begin with maybe just a little bit of legalese from the Department of Defense, Federal Register publication that's dated just really, less than 2 weeks ago, February 28th of 2020, and look at just the first 2 pages. So what's the title? Military Lending Act, Limitation on Terms of Consumer Credit Extended to Service Members and Dependents. The agency, the Undersecretary of Defense for Personnel and Readiness, Department of Defense. The action is the interpretive rule, and let me read a little bit of legalese to you, the summary as it relates to this new bit of information. So here we go. The Department of Defense is amending its interpretive rule for the Military Lending Act. The MLA, as implemented by the Department, limits the military annual percentage rate that a creditor may charge to a maximum of 36%, requires certain disclosures, and provides other substantive consumer protections on consumer credit, extended to service members and their families. On July 22, 2015, the Department amended its regulation primarily for the purpose of extending the protections of the MLA to a broader range of closed-end and open-end credit products. That is the July 2015 final rule. On August 26, 2016, confused yet? The Department issued the first set of interpretations of that regulation in the form of questions and answers. Here we go. On December 14, 2017, the Department issued a second set of interpretations of that regulation in the form of amended questions and answers. The Department, there's the focus, the Department is now withdrawing the amended question and answer, number 2, Q&A number 2, published in the December 14, 2017 interpretive rule, which discussed when credit is extended for the purpose of purchasing a motor vehicle or other or personal property, and the creditor simultaneously extends credit in an amount greater than the purchase price of the motor vehicle or personal property. In withdrawing this amended question and answer, the Department is reverting back to the original Q&A 2 published in the August 26, 2016 interpretive rule. This will allow the Department, and here's the key thing that Dave will discuss, this will allow the Department to conduct additional analysis on this matter. The department is also adding a new question and answer to address the question about the use of individual taxpayer identification numbers, TINs, to identify covered borrowers in the department's database. So, ladies and gentlemen, with that little bit of legalese in mind as a lead-in, let's welcome AFIP's Executive Director and President, Dave Robertson. David?
Thank you, Bob. You know, the simple answer to this is remember how we did it in the old days as it related to people in the military. We treated them like anybody else in terms of offering gap, credit life, and accident and health insurance. So what Bob was saying is as of February 28th, 2020, it's like the old days. So the 36% APR and all those things no longer apply. The point is, it's like it used to be. But on the other hand, it's really not. Because what Bob mentioned is that the Department of Defense stated that they're going to give further studies to the sale of these products. You got to remember that the military decided to make this decision to stop gap and credit life and A&H because somebody convinced them it was bad medicine for the people in the military. And so in revoking their standard, they didn't say, we really think gap is a good deal. What they're saying now is that we're going to give it further study, but we think some military people are hampered by the fact that they cannot purchase gap. Now, how does that impact us, the people working in the box? Well, number one, we're going to have some oversight by the military on gap. But let me put it in a broader perspective. We're in an election year, and there's a lot of focus at anything that will allow a candidate to get some traction. And so we're not in a good time to even have this issue come up. So what do we do if we're working in the box as it relates to gap? Number one, when you're selling a vehicle to a military person or their dependent, and you're thinking about offering gap, there has to be the potential for a substantive gap before you offer the coverage. In other words, don't sell gap to somebody where there is no gap. Because I can tell you, if the Department of Defense in their investigation starts hitting some stores and finds out people are buying gap that don't really need it, then we'll find the courtesy they've extended us so far taken away. So the first thing is we have to make certain there's a gap. The second thing we need to do is make sure that the price we charge this military person, the retail price, is commensurate with the dollar value received. We're going to talk a little later today about the spotlight on aftermarket products and are the consumers getting a fair shake. And the standard the government's going to use is what I paid for this product at a retail price, the cost of funding that retail price for 60 months, relative to the value received. So when you're pricing your gap, make certain then that you have a reasonable price, one that you can defend. The third thing you want to do, is that you want to make certain that you give a full disclosure. Because you're talking to people, usually younger people aren't that versed in the ways of the car industry, but they need to understand implicitly what the gap does, what their responsibilities are under the gap. You need to know if it's cancelable, if you have a 30-day free look period, they have to be fully versed on all the dynamics of that transaction. Because if we do it right and there's nothing found amiss, then this reprieve we've got, look at it this way, of being able to sell gap to people in the military and their dependents will stay with us for the long run. Bob?
Thank you very much, Dave. I was remiss to say up front that if you have any questions or comments about what Dave just discussed or the MLA, you can hit the Q&A button at the top of your screen and just type that in and shoot that into John Friedland, and we will take your Q&As as we go, even though we'll be addressing some other topics, because we want this to be your webinar, as we always do. The focus was on Military Lending Act. So again, feel free to submit that information to us. Dave, anything else with respect to MLA
I'd
right
like
now?
to talk a little bit about a best practice. You know, the Association of Finance and Insurance Professionals deals with F&I processes. And this doesn't apply just to military people, but consumers in general. And many times we're in a situation where the customer wants to buy the gap, but legitimately there's no gap in the transaction. So you're kind of caught between a rock and a hard place because you make money by selling a product that the customer now wants, but it's questionable if the customer has an appreciable benefit for that product. So here's our best practice on that situation. If a customer asks for gap in a deal that doesn't have gap, the first thing you do is you tell the customer explicitly, sir, there is no gap in your transaction. If the customer understands that, the gap sale doesn't go through, that's fine. If the customer persists, then you do the following. You take a sheet of paper and you write on there that you have, at a certain date, explain to the customer that he does not have a gap in that transaction, but he is determined to have gap, and you're going to include it on the deal, and you and the customer both initial that particular document, and then you put it in the deal jacket. There's nothing wrong with making notes to file, as they call it. So you have covered yourself, you have told the customer there is no gap, the customer has expressed a desire to continue with the process and purchase the gap, and that he's been properly briefed on the fact there is no gap, and both parties agree by their initials as to the situation that has prevailed in that transaction. Bob?
Very good. Thanks, Dave. Let's switch gears now and get into, again, AFIP information. And let's discuss primarily, I would say, for compliance officers, comptrollers, and office managers, let's address the AGWSU/AFIP compliance checklist and dealer aid solutions offerings, if you will, as they relate to the safeguards rule, red flags rule, and disposal rule. With that, let's go into the vulnerability checklist, and let me just reference the information at the top. The Federal Trade Commission requires franchise automobile dealers to implement a written Consumer Information Security Program, ISP, under the direction of an appointed corporate compliance officer, and to update their program periodically. As you may know, that was effective May 23rd, 2003. That's the safeguards rule, and it's amazing how many dealerships I go into that they either haven't done that yet or certainly are not reviewing it on any kind of a regular basis. Dave will address that in just a minute. Second paragraph, the Federal Trade Commission requires franchised automobile dealers to implement a written identity theft prevention program, ITPP, under the direction of an appointed corporate compliance officer, and to update their program periodically. The effective date of that, December 31, 2010. That, of course, is the popular or ever popular red flags rule. The penalties for noncompliance are severe at the federal and, when applicable, state levels. In addition, a dealer found not complying may be open to civil action initiated by the individuals whose non-public personal information has been compromised. The negative press stemming from the fraudulent use of non-public personal information impacts floor traffic for an extended period of time. And we've seen that in some of these cases. Dave, let's begin. How about a great definition and clarification, illustration, whatever? Help us out with understanding non-public personal information.
Thank you, Bob. The way we define NPI, or non-public personal information, is by telling you what's public information. Anything I can find out about you legitimately on the internet or in the phone book is public information. Everything else is not. Driver's license numbers, social security numbers, credit card numbers, everything else is non-public personal information. So when we talk about protecting NPI, it's a broad field.
Thanks, Dave. Now, this vulnerability checklist takes really less than 5 minutes to complete for really all three rules that we're talking about: safeguards, disposal, and red flags. I want to start with safeguards, and there's really 15 questions or thoughts here to consider. And I've checked 3 or 4 that I'd just like Dave to comment on as far as their importance and maybe how to do it, not so much why, because it's the law, but what happens if we don't and when bad things begin to happen. The first one is just the first question there. Does the store have a written information security program in place under the direction of a corporate compliance officer? And Dave, as you address that, how is the compliance officer position coming along with respect to percentage-wise for our dealerships in America?
Well, you know what, Bob, if you had a gun to my head, I probably wouldn't tell you. But the point is that the number of people who should be in compliance are not. But let me take just a moment on that. Everybody is quick to tell you in the car business, NADA and what have you, on what you need to do. But nobody is there, or not very many people are there, to help you get it done. And so the AFIP approach, or in this case, the member benefits approach, is to provide the tools necessary to do it. We already know we're supposed to. What we want to do is give you the guidance to get it done.
Dave, stay with me on a couple of these questions now. Just going to drop down 3. Do you limit access to customer information to personnel who require access for their jobs? Comment on that and the importance of compliance.
Well, the way you have to do that, Bob, or at least under our program, is that we divide the store into secure document areas and secure document workers. So we define right up front at what point do we have to have controls over NPI and what parts are open to the public. And so by segregating the dealership, then we can identify the people who work in those areas and prepare processes and policies for them.
Okay, Dave, drop down a couple more. Have physical or procedural changes concerning where non-public personal information is divulged, recorded, processed, or stored been noted in the updated information security program? So talk about updates and just what should be in there.
Well, the categories change, and like anything else the government puts out, they keep changing it, and we review our programs with attorneys on a frequent basis. But what we're identifying is that information that belongs to either customers or consumers that have compromised that would be to the detriment of those individuals.
Dave, one more with respect to safeguards. Let's drop down 2 questions. The ever popular locks, and I look for that in stores that I go into on a regular basis. Are the required door and desk locks, computer passwords, and hibernation systems operative? The firewall is adequate and operative. Comments on that, if you would.
Well, this is a vigilant situation. I mean, you can't come in one day and say this is our policy and assume it's going to get done. So most corporate compliance officers on the safeguard side have set up a routine where when they come to work or go to lunch, they walk around the store at a certain area and look at certain areas to make certain that what was a policy 6 months ago and everybody pledged to do it, over time becomes I need to run down the hall, I won't lock my stuff up, getting caught and monitor then and take action against people who don't abide by it.
Very good. So just 4 questions there and answers related to the 15 that's part of this checklist regarding the safeguards rule. Next is the disposal rule. 3 questions there. The one that I want to point out and have Dave comment on, 4 questions really, is the second one down. If a document destruction, shredding service is employed, did the vetting process satisfy the standards imposed by the disposal rule? Can you comment on that, Dave?
Yes, there are very specific standards the disposal rule has established in vetting and hiring a document destruction company. And in order to satisfy the disposal rule, the dealer's program has to satisfy all of those requisites. Your company has to be properly vetted. Have you got references? Do they belong to a creditable trade association? So there's a series of steps. Nothing is onerous and easy done, but they all have to be completed.
Let's drop down to the red flags rule, 12 questions here. Dave, if you would, speak to 3 of these, and the first one is, the first question, does the store have a written ITPP, Identity Theft Prevention Program, in place under the direction of a corporate compliance officer? Sir?
The thing you need to understand is on the safeguards rule, people steal information out of the store, NPIs, usually disgruntled employees or amateur crimes of opportunity. But now we're getting into the red flags rule where we're dealing with professionals and we're talking about purchases of vehicles using somebody else's identity. And now that's a professional situation and these people are good and it's a present threat. I was in Colorado recently. A group went through the Front Range dealers. They got out of there with 7 stolen cars or cars stolen on somebody else's identity. And they weren't stealing Kias. It was Lexus or better. And nobody got caught.
Okay, Dave, let's drop down 4 questions, I guess, for red flags and wrap it up with this. Have the programs published compliance requirements been monitored regularly with documented action taken against those who failed to comply? That's an interesting thing there from a management standpoint and just compliance with the rule itself. Dave?
The program that we've established creates job descriptions with everybody who has NPI responsibilities, both on the safeguards and the red flags side of the business. And so when we install the program, we make them initial line by line every responsibility they're supposed to have in those positions. And so we have then a policy, it's been related to them, they have committed by their initial that they understand it, they understand they have to comply with it, so it sets up the requisites then to hold people accountable for their actions. And the one thing that makes this work is accountability. I do want to talk one quick thing. Where you're going to get in huge trouble is if you've done nothing. If a regulator comes into your store either on an inspection, and a lot of states have their own safeguards program, or there's a breach, then the best you can do is pull out a bulletin you think you got from the State Dealer Association. You just told that regulator, I don't think you're very important. And he's going to spend about 2 weeks in your store telling you just how important he is. I want to give you a comparison. I gave a talk a while back about marks on the board and high gross. And I wasn't talking about car dealerships. I was talking about people who come out and provide inspections for the stores. And if I want to get promoted as a government agent, it's how many dealers can I bust and how much money can I generate in penalties. So everybody's in this business to get ahead, and they're in it to get ahead by performing within their job description, which is always marks on the board and high gross. So you have motivated people that want to make certain that you're doing what you're supposed to do. These programs in our program are simple, they're easy to follow, they all make sense, and they've been reviewed by competent attorneys. There's no reason for a dealer to get caught short on red flags and safeguards.
Thank you, Dave. So, ladies and gentlemen, as you complete this checklist for yourself and your stores, and really it's 3 checklists, right? One for safeguards, one for disposal, and one for red flags. Look at the bottom of the page that's displayed right now. Did you mark an X or 2? Did you mark an X or 2 in the no column? Question mark. Good news is no problem. A proven solution is at hand. A proven solution is at hand, and we're very proud to share that with you. And that is the AFIP, AGWSU, Dealer Aide NPI Solutions. Dave, step number 1, appoint a qualified corporate compliance officer. Step number 2, contact Dealer Aide at that number in the extension, or dealeraide@afip.com. But Dave, would you take it from there, as it says, and talk with us about one-on-one support from the start, tailored to your unique needs in the store, installation and ongoing management, and boy, that's where it just breaks down in so many stores. We get off on the right track, the right foot, whatever, and there's never any reference to checking it again. Unless something bad happens, then there's the contact, obviously, of Dealer Aide NPI Solutions, been doing it now since 2004. Dave, would you address the solutions?
Yes. What we say is this. I mean, what happens in a store is the dealer calls the office manager in and says, Millie, now you're the corporate compliance officer. And all she knows is there's a raft of government regulations. They don't know where to start. And so what we have done is given them the guidance and the systems to put it in an organized manner. We have a binder that we put it in. We have job description templates for both the corporate compliance officer and everybody with duties. We have signs to put up around the store. We have a sign that says this dealership's in full compliance with the red flags rule regarding identity theft. So if somebody came into your showroom and they want to steal a car under a stolen identity, and they see that sign, unless they can't read, they probably won't do it in your store. So what we do is we take complex processes and break them down to easily doable standards and rules and procedures. So we simplify it and we put it all in a handy binder so everything relative to your program is in one spot. And I can tell you, if somebody walks into your store and says, do you have a program, and you hand them about a 15-pound binder with everything in there, the marks on the board and the high gross, nah, not in that store. Just not going to happen.
Thanks, Dave. Ladies and gentlemen, here it is. The signs and binders, dealer aid, bottom left, a single hand it to a regulator binder. What a great phrase that is. A single hand it to a regulator binder houses all NPI material in one place. Program is reviewed by industry attorney experts, recently updated. You'll receive timely program change alerts. There you go. Right-hand side, the Dealer Aid NPI Solutions package includes signage and user resources. Dave, maybe just a minute before we get off of Dealer Aid, you can address the signage again and how stores are utilizing that. And then last but certainly not least, online training is supported by itemized task-specific job descriptions and includes a certificate of training. Dave, would you address the customer notice and signage one more time, maybe?
Well, what we want to do is identify areas. For example, do we have filing cabinets that have NPI in it? We want to put a sticker on those. We want to divide the store and put signs on the doors that says secure document areas. So people who are not trained as secure document workers don't have access there. So we have clear demarcation lines between those who are required and trained to handle non-public personal information and those who are not. We give organization to a complex process that in its application is simple.
Thanks, Dave. Again, folks, if you want to contact us, you hit the Q&A button, the mark, and just shoot that information to us. We'll be happy to stop and address what you want to talk about. Well, Dave, we've addressed Dealer Aid Solutions, NPI. We've done the latest Military Lending Act update. Let's move now to the best practices for rate administration and product pricing, and talk about the NADA programs. The first one being in 2015, the National Automobile Dealers Association's Fair Credit Compliance Policy and Program, written by Paul Mitri, and specifically the Dealer Participation Certification Form. So Dave, would you kind of update us on this, step us through how this works, the 7 boxes potentially to check, and why this is important from a standpoint of compliance in case we're challenged by, as some would say, the dark side and or the regulatory agencies. The Dealer Participation Certification Form from the NADA, Fair Credit Compliance Policy and Program. David?
Yes, Bob. This is the outcome of disparate pricing. And you remember there was a series of lawsuits a number of years ago over people being charged a higher markup over the buy rate simply because they were a member of a protected class. And so we needed a way then to make certain that everybody was treated fairly. And there was a lot of discussions. There have been settlements, the Honda settlement on how the dealer should be compensated. And the standard that has emerged is called the Dealer Participation Rate Modification Form, or in NADA's version, the Dealer Participation Certification Form. And under this program, you charge every dealer in your store a maximum APR markup. Usually it's 150 to 200 basis points. And everybody starts out the same. And the government doesn't seem to mind that. Then, if for the reasons noted on the form, you have to deviate downward, then you identify the reason why you're going to deviate downward, the justification relative to the standards on the form. That way, if you're ever challenged, you have an argument that, well, I did it for this specific reason. Like anything else, these forms have to be handled properly or they'll come back and get you. There's an old saying that the right documentation is the best friend you ever had. Documentation done incorrectly will be the worst friend you ever had. And I'm going to give you a quick aside as to how that plays out in the real world. I do a lot of expert witness work, and I get probably 200 pounds of depositions from the plaintiff and the person that is trying to get out of this lawsuit. He did it, he did it, he did it, no he didn't, no he didn't. I get nothing but conversation, page after page. The only thing that drives that conversation and the final analysis is what's in writing, because the documents tell the story of what occurred at that point in time at a meeting of the minds of both parties, assuming that they were conducted non-fraudulently. So when you can fill out one of these forms and say that I've deviated down 50 basis points for the following reasons, customer can go to a better finance source, his credit union, the dealer wants to move some iron, there's a sub-vetted program, whatever. And you're accurately filling out this form, and it's reviewed. The NADA model has a reviewer of the actions of others, sound business practices. Then you have an argument if you're ever challenged. It's a fair way to do business. It meets the standards of the industry, and it's widespread. And incidentally, it works, and it's easy to do.
And we talked about that with a group just recently, and about the phrase that we use in class at our workshops, that documentation beats conversation. Documentation beats conversation. That's exactly what this is. No conversation, it's documentation. You know, you mentioned the really CFPB, Department of Justice, and really what began for the formation of this NADA program. And that was, you know, what happened to Ally Bank, Ally Financial, what was that, $98 million, and then a settlement with the CFPB and Department of Justice. Right after that, of course, was American Honda Finance. If memory serves me correctly, that was $24 million. Fifth Third Bank was 21, I think, 0.9, and then TMCC, Tidewater Credit Corporation, 21 million. So this is certainly a way to go. Bottom line is, if the final dealer participation rate does not equal the standard DPR, dealer participation rate, check the allowable deviation box below and fill in the corresponding blanks. You have a reason for what you're doing, a statistical basis for the rates charged to the customer. All right, let's switch next to the NADA Model Leadership Policy for Voluntary Protection Products. Specifically, the form that we're looking at here, the Voluntary Protection Product Certification Form. And again, this booklet, this recommendation, this information, all again authored by Paul Mitri from the National Automobile Dealers Association. Paul is the Vice President of Regulatory Affairs and Dealer Counsel for financial services. So Dave, you take this on, the Voluntary Protection Products Certification Form, the 5 allowable discounts, and just a comment or two about what we should consider as we set our SRPs, or standard retail price, for all of our products. Dave?
Thank you, Bob. This is a preemptive move by NADA. There's been a lot of interest shown by the CFPB, oddly enough, the plaintiff's bar, on are consumers getting a fair break when they buy aftermarket products. In other words, is the value received commensurate with the price paid? And so they want to start looking into dealership activity as it relates to aftermarket products, or we call them voluntary protection products. We don't want them to do that. No good's going to come from that. And so the preemptive move, and a good common sense and fair to everybody move, was put out by NADA, NAMAD, and AIADA. And what we do is somewhat similar to what we did on the markup over the buy rate, in that we set a pricing standard for the products we sell. Now, obviously it can be arranged, and of course the challenge in dealership products is the price for one service contract could be dramatically different than a price for a more full service contract. So how do you reach a common price that works regardless of what the price of the product is? The easy way is to do a dollar threshold. The problem is, if you do standard dollar thresholds, the price for one service contract might be really great and then ruinous or unfair for another service contract of a different configuration. What AFIP recommends is that you do a percentage, that you mark up the price of the product relative to its wholesale cost, and do it by a percentage. That way you keep the markup commensurate with the price of the product, and it varies then per product. All right, if you deviate from your standard pricing, just like we talked about earlier on the dealer participation form, you have to document it and subject it to management oversight. So here is a case where you, on a particular situation, have deviated from your standardized policy, and you're going to document it for management review to ensure that it follows the standards of all the participants in the program.
Thanks, Abe. Well, ladies and gentlemen, that's a great update, I think, as it relates to the NADA Fair Credit Compliance Policy and Program, as well as the NADA Model Dealership Policy for Voluntary Protection Products as it relates to rate administration and product pricing, which are two issues that we cover in all of our workshops and have literally dozens of questions a month related to that from people that contact us for help. Next up, we have, let's spend some time with information from Hudson Cook's Spot Delivery newsletter. What you see in front of you on the screen there is with my scribble on it, is the January-February 2020 edition of Spot. This is a monthly publication, although they always combine January and February, so in a year's time you get 11 publications. But this is the latest one. I've highlighted some sections there that Dave will make some comments on, and some general comments. Page numbers, service contracts, vendor service contracts, not just arm's length transactions anymore. That relates to what the CFPB is telling the finance sources what they have to do as it relates to policing the product providers that have their products and services on the contract. Page 8, Consumer Financial Protection Bureau. That's a discussion with Rick Hackett. Rick Hackett is a former Brown & Brown attorney, but also was a director with the CFPB. There's some great Q&As with that. And then last but not least is the CFPB Watch, page 12, if you have Spot Delivery in your store, where Michael Benoit from Hudson Cook talks about, again, the definition of abusive, talks about the change in penalties and many other things that's relative to what we do each and every day. So again, Dave, let's address the current CFPB, FTC, and attorneys general, if any that you have to share with us, hot topics as it relates to what's happening in our industry as we speak.
Well, I'll tell you what, Bob, because you've highlighted the ones that are important to you, why don't you run through them, and then I'm going to give you some closing anecdotes that will help emphasize what you're doing.
Yeah, let's do that. I'm going to go to page 8, and this is a Q&A that Tom Hudson, quite frankly, did with Rick Hackett. And I want to read a question and the answer, which I think is right between the eyes. And here's a question that Tom Hudson asked Rick Hackett. And he says, as long as the current director stays in place, and of course that's Kathy Kraninger, she was appointed by President Trump and confirmed by the Senate, did dealers and auto creditors really have much to worry about in the terms of the influence of the federal government on the business of financing and leasing vehicles to customers? That was the question to Rick Hackett. And here is Rick's response. This administration will certainly continue to honor the exemption that protects primarily franchise dealers. However, I believe finance sources would be prudent in continuing their current guardrails on dealer practices in areas like dealer spread over buy rate, F&I product selection and pricing, and garden variety problems like application fraud. Remember that a new administration will have a look-back period at past transactions on the books of finance sources, so good compliance now is insurance against a future change of regulatory vigor. So if there is that change, what we're talking about really kind of addresses that directly from Rick Hackett. Also from the CFPB is information with respect to definition, and that is what they're now saying with respect to abusiveness. Remember, abusive, they never really kind of defined that, but abusive, Webster says what? To misuse, use wrongly, or mistreat people. So here's what the CFPB is now saying. The CFPB will apply the following principles during supervision and enforcement matters immediately. First, the CFPB intends to focus on citing conduct as abusive in supervision or challenging conduct as abusive in enforcement if the Bureau concludes that the harms to consumers from the conduct outweighs the benefits to consumers. How about that for a little bit of legalese? Second, the CFP will generally avoid challenging conduct is abusive that relies on all or nearly all of the same facts that the Bureau alleges are unfair or deceptive. So without reading it, what it says after that is it really has to be over and above what they've already labeled as unfair or deceptive to now be considered abusive. But at least they've issued a policy statement with respect to that. And then, Dave, one more thing from this Q&A with Michael Benoit as it relates to the CFPB. Is the maximum penalties for violations of federal law. This relates to the FTC Act's sections on UDAP, and this hits a lot of areas. The used car rule, the advertising violations, whatever, after a cease and desist order, and this has gone up exponentially the last 4.5 years. So now for 2020, that dollar amount has gone up from $42,530 up to $43,280, and that's per violation. But in the case of advertising, as I always say, that's PDPV, which means per day, per violation. And Dave, the one that I'd like you to comment on is the one that's on page 7 of this, and it's vendor service contracts, about what the CFPB is saying that banks and the covered entities, the banks, the financial institutions that buy paper should be doing and monitoring the performance of the service providers. Can you address that at all?
I want to speak a little bit to all of them. Number one, the abusive acts and practices comes into play if it's under the jurisdiction of the CFPB. If it's not under their jurisdiction, then we go unfair, deceptive acts or practices. The CFPB then added abusive. But I will tell you this, if you take the words unfair, deceptive, and abusive and give them to a good lawyer, there's no end to how much hay he can cut with that information. As it relates to the markup over the buy rate, I want to give you a quick overview on what seems to be everybody's whipping boy, and that's the markup over the buy rate. If you look up in a book on the cost of loaning money, there are a number of expense categories that fall into play. We have a loan origination expense, the cost of money of putting the loan on the books. We have a debt servicing expense, the cost of money of collecting the payments over the term of the loan. We have a cost of funds to loan, expense. You got to buy the money from somewhere to loan it, and other expense categories as well. So when an F&I manager then meets with the customer and arranges the financing for that installment sale agreement, the dealer is incurring the loan origination expense on behalf of everyone who accepts assignment of that installment sale agreement. And then they incur the expense of servicing the debt. So what we do in the F&I box, as long as it's fair, is we're originating that transaction, a legitimate business expense, on whose behalf it is ever assigned to, whether it's Ford Motor Credit or Ally Financial Services. So people talk about Elizabeth Warren or Nancy Pelosi one day said that consumers lost billions a year by financing in the dealership. That's not true. The dealer incurred that expense. He has a right to be reimbursed, and that's all we're doing is providing then a way for the customer to get his vehicle financed, and all the people who have incurred an expense in the course of doing that are properly consummated. Now let's go back to the conversation about the funding sources monitoring people who provide service contracts and other aftermarket products. What they're looking for is a way to have some oversight that doesn't involve a government agency. And they're putting the people responsible for accepting assignments of those contracts in charge. And of course, we have the holder and due course rule that comes into effect too. In that if somebody gets into a lawsuit, whatever you can do to the dealer, you can do to whoever accepts assignment of that contract. So they have a vested monetary interest to monitor those dealers. So it is a positive program, an easy to manage program from a government standpoint, and say, you know what, fellas, you're advancing the money on this service contract. You have an obligation to see that the transaction took place under the proper set of circumstances and it's fairly priced and disclosed.
Hey, thank you, sir. Great job, as always. You know, Dave, you mentioned the UDAP, and every time you do that, I think of our good friend Terry O'Loughlin that's been with us, and he, of course, is the Director of Compliance for Rentals and Reynolds. So those of you that deal with rentals and DocuPad and the things that they do, hear from and see things from Terry on a pretty regular basis. In a previous life, as an attorney, he was also, at one time, the acting Attorney General from the great state of Florida. So with that, before I yield back to John Friedland to talk about our webinar schedule on AGWSU University, let me just say that from an American Guardian group of companies standpoint, and specifically American Guardian Warranty Services University, we work with our agent partners and dealer clients to help them develop both mission statements and value statements with their dealers, their dealer clients. And as we always talk about in every workshop, every webinar, is really a recommendation for a mission statement as it relates to the sale of F&I products and services. And that very simply is this: every customer knows what they're getting, they agree to buy it, they know why they need it, and they feel good about it when they leave our dealership. And then a training value statement, the one that we've adopted at the American Guardian group of companies, and it's really right on, spot on, as we say. And that very simply is this: we endorse and teach. We endorse and teach the industry standard and best practices that are recommended by NADA, that's the National Automobile Dealers Association, by AFIP, that's the Association of Finance and Insurance Professionals, and the AGWS, Seller Code of Conduct for Retail Sales, which serves as a guide to the proper sales practices for all retail sellers of our AGWS products. So with that, everything that we do from an AGWS standpoint is to help our agent partners and dealer clients maximize deal profit. Deal profit meaning both front-end gross, F&I income, variable operations, fixed operations, but to do it the right way. And the right way, of course, is in a manner that's consistent with good customer relations and sound business practices. Thank you all for joining us today for F&I Insights. We'll see you in April for F&I Insights. Continue this and look forward to chatting with you as you all have the link and are able to really download this and play this information back to yourself and do your own training in your stores or with your dealer clients. With that, Mr. Friedland. John?
Thank you, Bob. Thank you, Dave. So our schedule moving forward for the AGWS University, which is an in-person here in Warrenville, Illinois, is April 6th through the 9th. And then our next webinar is going to be on April 8th, that Wednesday at 1 o'clock Central Time as usual. Following that, again, it will be every Wednesday moving forward until 2021 for a webinar schedule. We didn't have any questions come in on the Q&A, or at least no real-time questions, but if you have any in the future, please feel free to email myself or Bob Harkins, and we can get back to you. Also, the recording will be available at the close of this call about 30 minutes after, so if you have any customers or other people you'd like to share this with, we can send that link to you as well. So again, thank you, Bob. Thank you, Dave. Have a good day.